Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. This video is for professional ethics students. The topic is already previously discussed whether lawyers or advocates can go on strike or not. The reply is 100% not. How to prevent the advocates from going on strikes or boycotts? Whose duty it is? BCI. This is once again reiterated by the Honorable Supreme Court of India while dealing with the case of an NGO by name Common Cause versus Abhijit and others in contempt petition number 500 by 2015 in WP Civil number 821 by 1990 in the shape of a public interest litigation, and of course this is posted to February 7th or so for final hearing. But the importance is how to prevent the strikes or boycotts by the advocates. To cite an example, I think in the month of November, Supreme Court expressed displeasure or seriousness over the continuous strike of the advocates of Odisha state, what for establishing a special bench or a bench of the High Court at Sambalpur. The issue went on for about a year or so. Entire work of that particular area has been stalled because of the strike or boycott by the advocates. Supreme Court said BCI has to take some initiative. But now Supreme Court observed that BCI should have suspended the licenses of the advocates or lawyers of Odisha who have been boycotting the courts for the past 1 year. But the lackadaisical attitude of the Bar Council of India is highly deprecated by the Honorable Supreme Court of India. Justice Dinesh Maheshwari and Madam Bala Trivedi. So they took strong objection to the BCI's lackadaisical attitude while considering the case or the petition filed by NGO Common Cause. To go to the back, why as previously discussed, of course this batch may not be known. Very famous case. Ex-Captain Harish KUppal versus Union of India, 2002 I believe. Uppal, 2002, yes. In this case, the Mr. Ex-Captain Harish KUppal, he filed a writ petition before the court that the strike by advocates should be condemned, should be declared illegal. Of course, the Supreme Court took a lenient view and they said the BCI would look into the matter. If you go to the facts of that particular case, Harish KUppal, actually, he was charged by the court with some embezzlement. He was a naval officer, ex-army officer, ex-captain, and he was a case of embezzlement or misappropriation was booked against him, and he filed his affidavits. The case was going on. Due to the lawyers' strike, the records were misplaced. That is the reason it was told, due to the lawyers' strike. Then he said, how can the lawyers go on strike? So that has become a contentious issue, and ultimately Supreme Court said that the advocates have no right to go on strikes. Here the important point is, Bar Council of India, in its framing rules, so they have not clearly stated that advocates should not go on strike. Supreme Court said, after all, this is a rule. Can't you insert a rule? Can't you insert a line saying that advocates are debarred or they are prohibited from going on strike and boycotts? Why are you not doing this? Why are you showing a sympathetic attitude? Of course, the other side also we have to do. Bar associations, they are formed under the Cooperative Registrars Society's registration. It's a union. What for a union is there to vent out the grievances? If lawyers who are the educated people in the society, if they don't take out the common causes, who else will say? Then when they are taking out the issue, normally they have to boycott the courts. There may be occasions where even our Ongole court went on strike for 6 months during the separate Andhra stage, separate Andhra program. So such things do happen, but Supreme Court has clearly stated that Bar Council of India should take some preventive steps or frame some rules to prevent the strikes or boycotts. Let us see what will happen. Okay, with this I am concluding. Thank you very much.